Hi, my name is David Shapiro. I'm a San Diego-based criminal defense attorney, and today I want to discuss with you what happens when you're charged with felony possession of drugs. And usually what that means in this day and age in the state of California is a large amount of drugs that are alleged to have been possessed either for sale or transported for the purpose of sale. A lot of times people will call my office and they'll say, hey, so-and-so, either myself or a loved one has multiple kilos or 500 grams of cocaine or heroin on them. They're going to have to do a lot of time, right? And my answer is, well, that depends. First off, they have to be convicted of something in order to be eligible to be sentenced. The second thing is, just because a certain number of drugs or a large amount of drugs is found, whether on their body, in their car, in their house, whatever the case may be, doesn't necessarily mean that they're going to be convicted, because there are many opportunities to try and get that evidence suppressed. If that evidence was taken illegally, if the search was outside the scope of a warrant, if there was no warrant, there's a lot of motions and a lot of things that can be litigated in court to try and argue to the court and basically say, hey, this was done illegally. The cops got these drugs illegally, therefore we ask that you keep the drugs and the evidence of where the drugs were found out of evidence. And without that, there's really not a strong case against you. So that's just one example of many of how you could beat a drug case.